I'm good.
I'm good. Oh, Stephen, by the way, sorry, are these the ones from the email? Oh, are we live?
I think we're live. Hey, everyone. Sorry, we had some technical issues here trying to get ready for our meeting. But if you are new, I am Betty. I am the interim executive director for Texas NORML. Joining me tonight is Jamie Spencer. He is our legal counsel. He has been our legal counsel for many moons now. We love our Jamie. He will be taking questions. So if you have any questions you would like to ask our lawyer, please feel free to post them on Facebook, on Twitter, on YouTube, wherever you're watching from. I have a few things I'm going to run down first to let everyone get those questions in. One of the big things from this past month that I didn't even know about until I saw it in the news on the 1st was that Germany has legalized small amounts of cannabis for personal adult use. That is adults ages 21 and up can possess up to 25 grams, that's nearly an ounce, of marijuana for recreational purposes, and it does allow individuals to grow up to 3 plants on their own. Some of the drawbacks is that it is prohibited, like smoking or ingesting. I found both. It's prohibited within 100 meters of the entrance to a playground or school or anywhere that children gather, seems to be it. But there was a big celebration at a square in Germany. I will post that right here. What else? We also have a membership drive going on for the entire month of April. You can get 10% off if you go to texasnormal.org. And I believe that code is TXN420 that you put in to the coupon code whenever you're checking out. What else do we have going on? I think that's actually all I have right now. I know we have some questions coming in. Thank you, Mikhail, for your question. Jamie, do you want to start answering some?
Sure. Okay, I'm going to, we have some that came in by email already. Let me start with those. So the first question that's been posed is, if I'm arrested with an ounce of marijuana on me, what is the typical punishment I can face? What sorts of fines and or probation am I looking at? Will I have to deal with anything that makes life harder? So I'm going to start, I'm going to answer them at least partly in reverse. I'm going to start with, will I have to deal with anything that makes my life harder? I mean, just based on you can beat the rap, but you can't beat the ride, which is a criminal defense lawyer's way of saying that even if I get you out of it, the journey may be unpleasant. I suppose the phrase comes from you can beat the ride, meaning the officer putting you in the back of the vehicle and taking you down to the jail. But really, the ride is more than that. The ride is paying for bond. Maybe you have, weekly, monthly payments that you still have to pay the bondsman, or maybe you have to check in with them, or maybe, depending on the county you were arrested in, the pretrial services office that lets you out added conditions like taking a don't smoke dope class, or, I hope there aren't, at least of the 254 counties in Texas, I hope there aren't a lot of them that are trying to require drug testing while out on bond for a marijuana case, but it's a possibility. So, I know that wasn't necessarily where the question was meant. It was kind of thinking of higher, bigger, what sorts of things, but just having this charge pending, even if you meet with a lawyer, hopefully if you meet with a lawyer in Travis County, where I am in Austin, Texas, that lawyer has any idea to know what they're doing. First off, it's unusual potentially for you to even to get that far, but they should put your mind at ease that, hey, in this county, it's really easy not to end up with a conviction and not even have to do a probation, not even a deferred adjudication. But that's not going to be true in every county. It's just not true. The big cities have all pretty much adopted policies. Really, they've done it for economic reasons. The most police departments don't want to spend, 3 hours out of an 8-hour shift booking somebody for marijuana when they know that the prosecutors are going to dismiss it. But the first thing, again, that I would say is, yeah, just having this hanging over your head is something that makes it harder. So I've kind of alluded to an answer there. I melded in the first part of that question. If I'm arrested with an ounce, what's the typical punishment I can face? It's really going to depend on the county, right? In some counties, likely the pot will be confiscated. You might not even get a ticket for it. If you do get a ticket, you may have to go to a justice of the peace. If a county has instituted those sorts of policies where they are ticketing instead of arresting for marijuana in the first place, I would hope there was a high correlation between that and getting a fairly easy dismissal. Again, even if it wasn't assigned as something that you do, I used to have clients go take an 8-hour don't smoke dope class where somebody talks for 8 hours about how terrible marijuana is, but you get out of there with that certificate and you get your dismissal. Or if the person has no criminal history, I would think that probation rather than jail in the other counties in Texas that don't have more reasonable prosecution policies that do actually prosecute these cases, typically it's going to be probation. Now, if you have a lengthy criminal history, that's going to change that as well. What sorts of fines and or probation am I looking at? Probation can be anywhere from 6 months to 2 years on a Class B or Class A misdemeanor marijuana charge in Texas. And depending on how they charge, probation often costs about $100 a month. First off, you pay $60 a month just for the pleasure of being on probation. That doesn't even go towards your fines and a bunch of other types of fees that the legislature has seen fit to add. So hopefully that's an answer to question one. If somebody wants to reach out more about that, let me know. Yeah.
So for everyone that's joining us, we are doing a Ask a Lawyer with Jamie, our legal counsel here. He just tackled one. We have quite a few coming in. Let me see. Hi, Christopher Lee Rayleigh. Thank you for joining us.
You know what? Let me take. I don't know if this is a question, Christopher, but I'll say yo back at you. So that's my answer to you, sir. And Nathan asks, what are your thoughts on employment drug tests for classic THC when there's now Delta 8? Can a test distinguish the types of THC or even Delta 8 would lead to a positive test result for marijuana? This is a great question. Unfortunately, I have a really easy and I believe accurate answer for you. Some of these questions I'm going to say it depends, right? Like the last question, I was a huge lawyer weasel. It depends on where you are, depends on what the policies are, right? It depends on your criminal history. This one doesn't really depend from a legal standpoint, in my opinion. Let's assume that there is an employer that wants to test for this. Alcohol is not illegal for somebody over 21 to possess or to consume, but if they test you on the job, they can fire you for having alcohol on your breath if that's part of the employment contract. Because of that, it hasn't come to it yet in Texas, and I'm not an employment lawyer, right? I'm a criminal defense lawyer. Actually went to law school 30 years ago. That's what I focused on. That's what my classes were. I really know the very basics of civil law at best. But this has come up within this context again and again. And I don't believe that if and when marijuana becomes completely legal, that there will be any prohibition for an employer for making part of employment testing for it. So since we're not there yet, right, to complete legality, Nathan, the answer is going to be that I think employers can test for it. Now, to split the hair a little bit more, what if essentially they have a Delta 9, no Delta 9 requirement, you have Delta 8? Well, This one I'm less sure of, but I think that long term, this won't be a problem for employers that want to do it. They'll just put in their contracts or whatever, or their rules and regulations that any kind of delta that folks come up with, whatever number comes after it, is also prohibited in terms of employment there. And I guess the last thing I would say is this. If you're fortunate enough to be a unionized worker and these sorts of issues come up, typically a collective bargaining agreement between a union and management is going to include some sort of due process hearing where maybe they have to jump through some hoops to prove something and it may be difficult for them. So there could be some scenarios where a union could protect you. Those are sort of my thoughts on that. And again, the normal caveat that I'm not an employment lawyer. Okay. How does the court look at open air sniffs now that there's legal cannabis? Shouldn't PC be null and void if the dog is marijuana certified? Another great question. Okay. So I'm going to have to take off my normal hat and put on my completely lawyer hat here, in part to answer this question. So there are various burdens of proof. The very lowest is called reasonable suspicion to detain. That means that the police officer has to have some reason to get in your business, some valid reason to get in your business in the first place. In most drug cases, this is based on a traffic violation, pulling a car over. But when the officer is doing that and using that very low standard, they don't have to get a jury out there and prove that you're guilty beyond a reasonable doubt of speeding before they, turn on the overheads to pull you over, right? It's just to get in your business. The next one is probable cause. So for reasons that will become apparent after I do it, I'm going to skip probable cause for now and then talk about the next burden of proof. That burden of proof is called preponderance of the evidence. That's the Lady Justice with her scales, who is just slightly more winning than the other. If you're 50% or higher, technically if it comes out 50-50, baseball, tie goes to the runner, the defense wins, but how many cases are like that? Slightly more than 50%, the plaintiff wins, or 50% or higher in the civil defendant's favor, then they would win that case. That is 50-50. Remember, reasonable suspicion is very low. Clear and convincing is 50-50. There are higher ones, but probable cause is between those two, which means that probable cause means it's less than 50%. And the thing that's weird about that from an English language perspective, is that the word probable means more likely than not. If something is, if there are two possible outcomes, getting arrested or not getting arrested, if one of them is probable, then the other one is less probable. You can't have two things that are both over 50%, right? So you would think that probable cause would mean that they would have to show that probably you're guilty of it, but they don't. Again, it's a low standard. So in states, and we're just going to have to find out what Texas is going to do about this, but in states where marijuana has become legal, one of the issues that the government still brings up in situations where it starts with, let me change the example. Let's say marijuana is still illegal, because that fits the question, okay? But other things that smell like marijuana are legal, and marijuana is illegal. So the question becomes, we don't even need a dog. Like, if the officer says, hey, I smelled the odor of marijuana, that's what gives them probable cause to search your car. And, the same thing's probably going to be true for a dog sniff. This, becomes an issue when, maybe my client has hotboxed his car. Free advice: do not hotbox your car. Do not smoke marijuana in your car. Your car's going to smell like it. You're not going to notice it, and you're going to get searched for whether or not you have dope in the vehicle that actual time, it's going to be a huge pain in the ass. So don't do that. But this becomes an issue when they find, felony drugs, right? And you want to go in and try to claim that, they should throw everything from the search out, because in theory, maybe, if you really did have Delta 8 or something that was legal, then they don't have a decent marijuana charge against you, hopefully. So it's what the state has argued is, look, the officer just has to have a reason to believe, a good reason to believe that it could be marijuana, and they're technically correct that in a pretrial hearing, in terms of a motion to suppress, they don't have to prove that beyond a reasonable doubt. The subjective intent of what the police officer is thinking at the time really has no bearing on the case. I guess the easiest way to think about that in terms of an example is, there are times when an officer thinks he's found some type of, let's say, non-marijuana felonious dope on my client. And he puts in the report, based on my training experience, I thought it was XYZ drug. Or even I field tested it. It came out with XYZ drug. But those field tests aren't any good. They're not going to be able to be introduced into court. They're not scientific enough. So imagine a scenario where they send it off and it turns out it's some other drug that is also illegal. And most criminal defense lawyers have had this issue. They're going to indict you on the second drug, right? There's nothing that the fact that the police officer caught you doing something illegal and he thought it was possession of X, but it was really possession of Y, is not going to help you. So I don't know the current status of this issue. Has been appealed in other states. It really hasn't been appealed in Texas yet. I think it's not really ripe for an appeal at this point, for reasons that are too long to go into at this meeting. But let me finish up the dog sniff section on this. Okay. I can't remember the name of it anymore, but I actually printed out the Wikipedia entry for an actual felony marijuana motion to suppress case. There was basically a carnival guy that had a horse back in the either late 19th century or early 1900s, and this horse could add. And they would come up and they would show, they would show it a 2 and show it a 4, and it would tap its foot 6 times. It could do a bunch of different addition. And a lot of people came and studied this horse because they were really interested. And the most likely explanation for what was happening was that the trainer was not, the trainer did not have bad intent, but that he was signaling the answer unintentionally to the horse, and that the horse could then do these addition things. It's also possible that the owner, the trainer, was doing that on purpose. But my point being, those drug dogs are bullshit, man. I mean, every conspiracy theory you've heard about the dogs, that the cop can just make the dog bark, and not only that, they could do it unintentionally. So I think there's a lot of problems with those cases. But I think it's unknown how Texas is going to deal with the odor of marijuana issue. We're just going to have to wait and see.
Perfect. Did you have anything else to say about that, Jamie?
No.
Okay. Thank you, everyone who has joined us. We have a lot of people on our live stream tonight. Thank you so much. If you're just joining us, my name is Betty. I'm the interim executive director for Texas NORML. This here is Jamie, our legal counsel for many moons. We are doing Ask a Lawyer today. If you're not a member, real fast, go to texasnormal.org, sign up. We are running a membership drive for the month of April, 10% off. That code is TXN420. Let us know where everyone is watching from tonight. We have some people from Atlanta. I hope some people are watching from Texas. Let me see here. Jamie, do you see a?
I do. Let me take Tessa's question because I think I got her initial question as well. So I'm going to put those two
Put them
together.
together.
So, and if this isn't it, Tess, I think it's probably pretty close. So the first part of it I got said the district attorney is offering a plea of either getting charges expunged, but doing a year probation, community service, and fines, or $750 for 1-day plea of guilty and nothing else. But he'll be able to file for non-disclosure in 2 years. What is the better option in your opinion? I guess what I need to ask first, if you just want to throw in the comments whether or not that was the was that yours? Because, by the way, that your second comment, pretrial diversion versus deferred adjudication, that makes more sense in that context. Let me start by just answering the pretrial diversion versus deferred adjudication, and then if somebody wants to put in chat that no, that other question was regarding something else, I'll address it. In my opinion, pretrial diversion is always better than deferred adjudication. Like, it is objectively better. And let me tell you about what I mean by that. I'm going to tell you something that I don't think it's fair for a lawyer to say for a client. It's objectively better for you to do 1 year of probation than it is for you to do 1 weekend in jail. Okay. You often on misdemeanors might have, a year or even 2 years of probation as an option, or just go run and do a little bit of jail time now, and you're not on probation. You don't have to worry about it. That's, I have people who, whatever they do, they would so much rather do probation than ever go back to that stinky jail, even for 5 minutes. They would totally jump on a year of probation or whatever. And I have some people who hate the idea of probation, and I'm in this second category. I'd do a weekend in jail before I did 2 years of probation, like Friday night through Monday morning. Okay, but the pretrial diversion versus deferred adjudication is a much simpler question for me to analyze as a lawyer and to give you an answer. The pretrial diversion should be expungible, and the deferred adjudication you should be able to get a motion for non-disclosure for. And expunction is always better than a motion for non-disclosure, and I'll talk about that in a minute. Therefore, I don't think I've seen a pretrial diversion agreement like this, but for example, if you had some sort of crazy pretrial diversion agreement that said, we want you to do 1,000 hours of community service in 2 years of pretrial diversion versus, 40 hours of community service for a 2-year probation or something. I mean, you could come up with some sort of scenario where the hoops that you had to jump through on the pretrial diversion were so onerous that it wasn't as good, but that's not what happens in reality. In reality, whatever a probationer would do in a particular county on a drug case is what they would do on the pretrial diversion, and maybe they would do less, but it's not. So, again, this is not specific legal advice to a specific person. If I were the lawyer, I would go over the terms of both of them. But I think that the terms are not going to be worse for the pretrial diversion usually than they are for the deferred adjudication. So that's a no-brainer. You do the same, you jump through the same hoops or even fewer hoops, and you get a better deal. Okay, so why is it a better deal? Well, the motion for non-disclosure, which you can get after a waiting period, depending on the type of offense, means that the government keeps the records, but they don't disseminate it to private parties and private individuals. Okay, that's pretty good. But in expunction, they wipe it out completely and the government doesn't keep the records. So, for example, if my client does go back to court after an expunction, and I have had those scenarios, even the prosecutor I'm dealing with doesn't know that my client has a prior arrest and did some sort of XYZ equals dismissal. All right. So, Nathan, thank you for asking. I actually currently am working for legal aid, and I cannot be hired. But I appreciate the inquiry. Okay, great, Tess. I'm glad that got to the answer.
Awesome. Thank you, Tess, for your question. Let me see here. Again, this is Betty, Interim Director, Executive Director, Texas NORML, here with Jamie, our legal counsel. Let us know where y'all are from. I actually just found out something. Looks like Massachusetts has pardoned all misdemeanor marijuana possession convictions. That happened 4 hours ago, y'all. This is really big. Looks like that Governor Maura Healey, sorry if I pronounced that wrong, has pardoned potentially hundreds of thousands of people with misdemeanor simple marijuana possessions convictions on their record. Jamie, how could that affect people in Massachusetts?
Yeah, that's amazing that they were able to accomplish that. It can affect people in a variety of ways, assuming that Massachusetts misdemeanor and felony laws kind of work like Texas do. There are certain types of licenses, to become a certain type of, either profession or whatever, where having a Class B or Class A misdemeanor can either make you jump through more hoops to get that license, or maybe disqualify you from having it for a while, which frankly is the same thing as potentially never getting it, right? Because now you got to go get a different job, and then when you're through that waiting period, you're at that job now. So
and that keeps you in the cycle of poverty more, that like whenever you were put into that by your first conviction. Okay.
That's right. And then if you think about the economy being cyclical, right? There are times when there are workers that can be a little bit, they either have to jump on whatever job they can get, or there's so few workers in the workplace right now. I mean, this is kind of what we're hearing, that maybe, hopefully, workers have a little bit more of an advantage on their side. But imagine a scenario where an employer gets 5 to 10 job applications for every listing that they put up, for every time they post a job. And that's not necessarily unusual, depending on who the employer is, right? One thing that I know that some companies do is they don't have time to interview 10 or 15 people. So they'll go through and say, okay, well, if somebody's in these 15 applications that didn't graduate high school, throw them out. If someone's ever been convicted of a felony or higher, or a misdemeanor or higher, or if someone's ever been arrested, right? There are ways that they can use these sorts of things to make general assumptions about you that you don't even know about. So it is absolutely true that doing anything other than getting a resolution where your case can be completely expunged and no one can ever find out about it, in more ways than one, that does follow people around.
Good. And so this will help people not get that. And awesome. That's what we like to hear. That's what, I think sometimes in legalization, we just focus on getting it legalized, and we don't focus about those who have come before, who have gotten these penalties for an innocent, harmless plant. And so I'm glad to see Massachusetts taking this step. Let me see if we have any other questions. Jamie, do you see anything else in chat?
I do. I have 2 others, and then if people want to ask more questions, you need to put them in quick, because I'll be getting through these too. Okay.
Take it away, Jamie.
So my son was charged with a felony and a Class A misdemeanor for bringing back gummies and flour from Colorado to Texas. This was in December of 2021. Wise County, Texas, never got around to actually getting the charges filed for the felony within the 3-year period time, so those charges will not stick. It's not really a question, but I'll comment on it. So the statute of limitations in Texas for a misdemeanor is 2 years, and for a felony, it's 3 years. Here's the first thing you've got to know about the statute of limitations. That does not mean if more than 2 years from a misdemeanor arrest, they haven't convicted you, that the case has to be dismissed, or 3 years in a felony. In fact, the person who wrote the note does seem to understand that, because they're saying that the case wasn't filed. We've all heard of an indictment. Sounds like a scary word. It's just a piece of paper. But in a felony case, the They are required to write down on a specific piece of paper and tell you and your lawyer exactly what you have to go defend. They have to say how you did it sometimes. Depends on what the words of the statute are, right? They have to write out an indictment and say, this is exactly what Jamie's client, Bob, did. Once that is filed, the statute of limitations stops. So if it is true, I mean, what this person needs to do is they probably need to just find a local attorney who can verify for them that they were never indicted. This isn't necessary in theory, but I would want that lawyer also to file a motion to dismiss based on the statute of limitations, so that you knew that your folder wasn't like, on somebody's desk in the DA's office, and they pick it up under everything else and they take it to the grand jury and they indict you. I mean, you'd be able to get that dismissed later on, but I think that would probably be best. But yeah, if you truly made it past 3 years without them filing that specific piece of paper at the district clerk's office in a felony, or a county clerk's office as a misdemeanor, you're golden. But I think it's worth going and trying to get your dismissal.
Perfect. Awesome. Thank you for that, Jamie. Let me see again. We are having a membership drive right now for Texas NORML for the month of April. If you go to our website, texasnormal.org, you can get 10% off memberships there by entering in TXN420. Did you have anything else, Jamie?
I've got a question that says, if I'm flying from LA to Austin and I'm approached by TSA, what is my best course of action if they ask me about gummies edibles? Your best course of action is to immediately get a time machine and go back 4 hours and not take edibles on the plane with you into Texas. And I'm sorry, that is absolutely your best option. I just have to start with, don't do it.
Be harsh to us, Jamie. Teach us.
And I mean, at that point, if for whatever reason they, I have no knowledge that TSA is looking for marijuana in Texas or other states where it's still illegal. So I don't know that they're going to go out of their way to harass people, but this just is not worth. This is not worth messing with. I hear you. I like gummies and edibles too. Don't bring them on a plane. And if you get caught, say as little as possible. Be polite and cooperative. And if you need a standard line, if they're grilling you, because it can feel socially awkward, you could say, look, it's me, right? We met tonight. So you could say, I've got a good buddy who's a criminal defense lawyer, and he told me that if the cops ever question him, I have to call him first. And they're not going to let you call me. So that's your excuse for not talking to them, and just be polite. That's what you should do. And I think that's close to wrapping up what we have here.
Yes, I do think that is it. Let me see here. Yeah, I think that's it. Thank you.
We do have a couple more questions, actually, if we've got time for them.
Jamie, do you have time?
Oh, I see. Sorry, I see that there are, Stephen has just put some more in. So what's the difference between D9 and Delta 9 found in marijuana that makes Delta 9 weed illegal and D9 legal? So I have very definite thoughts about this, and I'm just going to say it. For the most part, I'm unwilling to explain my thoughts on it in a public forum because I don't want to help the state prosecute people. What I want them to do, which they've done in a lot of jurisdictions, is throw up their hands and say, we can't tell the difference between any of this stuff. We're just going to stop prosecuting it all. I guess let me put it this way. I can have my thoughts and my legal arguments for why something is or isn't legal in Texas that's very similar to marijuana. However, I'm going to go back to, we could circle this around to the beginning. You can beat the rat, but you can't beat the ride. That's part of it, right? So, I mean, by now, if you're talking about gummies and edibles, you're talking about the charge being marijuana. I know you want to say it's not marijuana. Marijuana not in flower form, not meaning FLOWER, the flower ground up, right? Once you do that and you make pot butter and you put it in your brownies and your gummies or however else you get there, you automatically start at the state jail felony level, and you very quickly, only 4 grams, you get to second-degree felony, 2 to 20 years in prison. I am still concerned that there will be prosecutors who try to make their bones by being harsh in some little Texas county and showing how they can still make arguments that these alternate substances are prohibited. And again, in terms of this being a public forum, maybe someday you'll meet me in a coffee shop and I can tell you there, but I'm not. I don't want to say what I think the state's theories could be to still prosecute for literally the things that you can buy here in Austin by going into the stores and buying D9 products off the shelf. I think you're probably safe in a place like Austin. They've given up. They've decided they're not interested in prosecuting these types of offenses, which is the correct attitude that government ought to have. But if you're in a place that cares about these things, I think the best legal advice is you need to be super careful. And then there's a question on THCA, when I think any thoughts on the future legality of it? You know, when we're talking about things that aren't actually the flower, I mean, that's kind of what I concentrate on. I guess my answer to do you have any thoughts on the future legality of THCA is this: we need to make it all legal. If we spend a lot of time carving out tiny little exceptions for, you know, these sort of fringe substances, that's not the right way to go. And I don't know that, I think we've just reached the place as a people. I mean, about 90% of Texans want the law repealed. They think it's a bad law. It's just that we live in a society where 90% of people can want something in a state and it still be extremely difficult to get that. But all right, I think that's most of everything.
I do believe so. And that's what you were saying, Jamie. That's why we do what we do. That's why Texas NORML is here. That's why we network. That's why we reach out. That's why we organize and learn ourselves to change these unjust laws in however we can. Thank y'all so much for coming to our immensely successful live stream. Again, check out our website for all your membership and Texas NORML swag needs. We will be having our next live stream the first Wednesday of May, or that will be May the 1st. Oh my God. So we will see y'all then. Thank you so much for coming out. And thank you, Jamie, for coming out and sharing your wisdom with us.
You're welcome.
All right. Thank you all. Y'all have a great night.